Welcome to Ducks in a Row, the Estate Planning Guide.
Welcome to the Ducks in a Row, the Estate Planning Guide with attorney Erin Nunes, one of the managing partners at Supernut, Benesky & Nunes Estate Planning and Elder Law. Erin and her team of dedicated legal professionals are helping Southeastern Massachusetts families plan for tomorrow today. I'm your host, Lisa Mosby, and I'm here with Erin to dive into why most families wait for a crisis to talk about estate planning and how to make sure you aren't one of them. The team at Serpent, Benensky and Nunes Estate Planning and Elder Law are local experts dedicated to turning complex legal hurdles into clear, proactive roadmaps for adults and their children. Welcome, Erin. Before we get started, I really want to know a little bit more about how you and your team came together. Will you share a little bit about your story with us, please?
Sure, absolutely. The firm actually started out with Dan Serpernot and Michelle Benesky's father, Robert Serpernot. So he was a solo practitioner for many years, and he, kind of did a little bit of everything, a general practitioner. And at a point in his life, he needed to focus for his own family on elder law and learned what a complex area of law that this is. So he, along with his daughter Michelle, went into business together, focusing on estate planning and elder law. And then Michelle's brother and Bob's son, Dan Serpernot, he joined the practice. Bob retired. Um, and they ran the business together for almost 20 years or so. I actually came to know them because I was the nanny for Michelle's 4 kids when they were babies. They're grown adults now. And when they no longer needed a nanny because they were older, she invited me to come and join them in the practice. So I started out as a legal secretary, and then a paralegal, and I really loved what we did. I was inspired by the good work that Dan and Michelle were doing, and I wanted to be able to contribute more. So I went to law school at UMass Law in Dartmouth, and I worked full time while I was doing that. And fortunately, I passed the bar and became a practicing attorney, and then became an associate, and then a partner, and then I was very fortunate enough last April to become one of the named managing partners. So we have over all those many years, 20 some odd years, we have a lot of trust built up, and we really rely on each other. So we're super fortunate.
And it's such a great story. So thank you for sharing that with our audience. And honestly, I'm looking forward to this because my clock has been ticking and all of us are moving closer and closer to that day when we need to know what our next steps are. So, can you tell me how common is it for someone to pass away without a plan in Massachusetts? And then who steps in to decide who handles the bank accounts and the funeral arrangements?
So it's unfortunately really common. Um, and when you don't have a will in place that nominates who you want to represent your estate after you've passed away, then there's kind of a hierarchy that the law in Massachusetts outlines. So, it might be a surviving spouse or it might be your children, kind of depending on your family situation. But there's an order in which people have the right to represent the estate, assuming they're fit to do so. So someone has to actually petition the court to become the legal representative of the estate. That role used to be called an executor. Now it's called a personal representative. A lot of people also think that if you are named in someone's will as the personal representative, you automatically are. But that is really just a nomination. You don't have any authority until the power is vested in you by the probate court. So it's either a will that designates who the person wants to handle things, or if they don't have a will, then either the order that the law sets forth, or if everyone can be in agreement amongst the family, then they can nominate one particular person who would then petition the court to become the personal representative.
And it really seems like many people assume that everything automatically goes to the spouse. Why is that a dangerous assumption under Massachusetts law?
It's a really dangerous assumption because that only happens in one narrow circumstance. So if you have, a traditional nuclear family, two spouses, all children of the marriage, if you don't have a will, then yes, your assets are going to go to your surviving spouse. But if you fall anywhere outside of that, it is likely not going to happen that way. So if either of you have children from outside of the marriage, not everything is going to go to the surviving spouse. If you have no children and you have surviving parents, not everything is going to go to your surviving spouse. Your parents are probably going to be included as well. So and it might not even be your children. Perhaps you want to skip over your children and you want things going to grandchildren or, godchildren or nieces or nephews. If you have specific wishes about who you want to get what and how, you've got to have a will that outlines that because it is likely not going to comport with what the intestacy laws of Massachusetts say will inherit things.
Is there any way to avoid probate if someone dies without a will or any other estate planning in place?
Yeah, absolutely. So probate involves assets that you own individually when you die. So if I'm the only owner on my home or my car or my bank account, then the way that those assets get to my intended beneficiaries is through probate court, either through the instruction that I leave in my will or through the intestacy laws in Massachusetts. But if I have a joint owner on an account, if I have a beneficiary designation, for example, on life insurance or an IRA, or if I have assets that are owned by a trust, a revocable trust or an irrevocable trust, all of those will avoid probate. So that particular asset is going to pass to the surviving joint owner to the beneficiary designation or via the trust privately to whoever I've named as the underlying beneficiaries of the trust. So there's lots of different ways that probate can be avoided if that's a goal that a family has.
And then, from an emotional standpoint, how does the stress of a messy probate process often lead to like permanent sibling shifts or rifts, we'll say, that last long after the money is gone?
Yeah, it's really, really hard. Sometimes when there's little perceived slights throughout life, disagreements, this child was favored over that child. If you haven't provided clarity and thoughtful reasoning to your beneficiaries when you pass away, whether it's through a will, whether it's through a trust, then that can just harden those positions and those thought processes. So it's really important to be clear about what your wishes are. I also like to encourage families to help people understand why I've chosen this particular disposition in my will or in my trust so that there's not a lot of finger pointing or, you took advantage of mom or dad or you unduly influenced them, those types of things. The more clear you can be with your family about what your wishes are, what your intentions are during your lifetime, the easier it makes that process of having to finalize and deal with things after a loved one has passed away.
And I know from a personal standpoint, I've met folks who are just really unclear about blended families. How does the property get, split up? How do the shared bank accounts get broken up? What happens to joint property like a home owned with a spouse or shared bank accounts when we run into these blended family situations? Can you maybe give us a scenario or a bit of a more of a breakdown on how that all works?
Sure. So if you've got, a blended family with spouses who, each have, let's say, two children from prior relationships. And they're joint owners on all their bank accounts, checking, savings, money markets, things like that. Then those assets, those bank accounts, are going to pass to the surviving joint owner when the first person passes away. For real estate, the answer is it depends. So there's a couple of different ways that real estate can be owned. So even amongst spouses, you can own real estate as tenants in common, basically meaning each person owns 50%. And when that person passes, their 50% interest is either going to pass according to the terms of their will or the intestacy laws, but it's not automatically going to pass to the surviving owner. So that's one way. The other way is joint tenancy with right of survivorship. And that basically means that when one spouse passes, the other one's going to own it in its entirety. The third option is specific for married couples, and that is called tenants by the entirety. And again, with tenants by the entirety, the surviving spouse inherits the property. The main difference between joint tenancy and tenants by the entirety is with a joint tenancy, you don't have to be a married couple to have it that way. And either owner can sever the joint tenancy. So if my husband and I own our property together as joint tenants with rights of survivorship, and I decide, no, I don't want husband to get all of it, I want it to go to my two children, I can essentially deed my share in a way that's going to not go to him and it's going to go to my children. With tenants by the entirety, one spouse alone cannot sever that tenancy. So it has to be a joint decision to change the way that that property is owned. So for a married couple, whether it's going to go to the surviving spouse or not depends on how they own the property together.
And then if there are minor children, who decides who raises them when there's no will?
So again, that's going to be the court. So someone is going to presumably petition the court to become the guardian of the children. And that may not be the person that you ideally would have wanted. But all things being equal in the eyes of the court, if that's the person that comes forward and they are reasonably fit to be the guardian, then that's who your children may end up with. So again, I have minor kids of my own, and I think in a terrible situation where my husband and I are taken from them, that's traumatic enough. It is critical to have a plan in place that provides for them as seamlessly as it can be under those circumstances.
And it's not always the first thing on our mind. We're pregnant, we're having a baby, and then we have all the things to do, and, everything is foreign and new, and we don't think of estate planning at that moment. So oftentimes it needs to happen earlier on when you first get married, maybe, or at some point it needs to happen. But are there ways for families to make the process smoother once probate has already started? And I'm thinking in cases of parents, sometimes the parents don't have all of those things lined up, and here you are ready to take care of their estate. You end up in probate. There is no will, or the will wasn't complete, or it wasn't signed properly. What kinds of things can help folks make this a smoother transition?
I think gathering as much information initially at the start as you possibly can, that helps. When you're thrown a curveball kind of midstream, that can disrupt the flow of things, when distributions might happen, which can be um, alarming to beneficiaries and not something that a personal representative wants to have to deal with. So the more information that you can gather at the start of the probate process, the better. I also think the more transparent you can be, the easier it is. So more a family is able to communicate about where they are in the probate process, what the expectations are, so that beneficiaries know, okay, well, mom or dad passed away a month ago. Where's my check? Why am I not getting my check? Because there isn't a clear understanding of the timeline that's in place, when certain things are going to happen. So the more you can communicate about what the process looks like as it's happening, the easier things are going to be for you.
And I don't think you can ever be totally prepared. I know I went through it with both my mom and dad, and we thought we had all the I's dotted and the T's crossed, and it's surprise, surprise, surprise. It was like fireworks going off after the fact. So,
It's hard.
yeah. After seeing so many of these cases over the years, what's one message that you wish every Massachusetts family understood about why a will matters so much? And give us a little motivation to get folks in to take care of this sooner rather than later.
So again, I think if you have a dispositive beneficial scheme that is outside of, the norm, if you will, then it's critical to have a will, because otherwise the wrong people, or the people that you don't intend to receive your assets, are going to get them. And when people learn that, that is immensely troubling to them. So having that knowledge is really, really important, and then taking action on that knowledge. And if you have a particular person that you want to be in charge of things, having that will allows you to nominate who you want to be the representative. You might have two children that, all things being equal, one is, really good at paperwork and really good at staying on top of things and deadlines, and another lives next door to you but would hate to have that responsibility. All things again being equal, those two children are going to have the same right to represent your estate under the laws of Massachusetts. So you may want to relieve one child of a burden that may be very difficult for them, and nominate the person that you would want, just so that things are clear.
Well said. Thank you so much for your insights today. And to our audience, thank you for joining us on Ducks in a Row, the estate planning guide. If today's episode helped clear the fog on estate planning, please like, share, and subscribe to help us empower more families across Southern Massachusetts. Don't wait for a crisis to start your roadmap. You can find more educational tools and schedule a consultation at myfamilyestatePlanning.com. As Erin and the team at Serpernut, Benensky, and Nunes say, the best time to plan is now. We'll see you next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.